This video contains excerpts from an online workshop that the U.S. Asia Law Institute held in June 2020. The workshop participants were legal professionals or scholars from mainland China, Taiwan, and Japan, who were already broadly familiar with the United States criminal procedure and evidence rules. The presenters were experienced judges, defense counsel, former prosecutors, and law professors. The workshops were designed and led by U.S. Asia Law Institute Senior Research Scholar Ira Belkin, a former federal prosecutor.
For today's talk, as we've been preparing for this project, it's become clear to me that the evidence rules in the United States are designed for a different kind of trial process than the trial process in China. So to understand both systems, I think we have to start with what is the starting point for the evidence rules and how do they work with different trial systems. So for purposes of today's discussion, when we talk about the rules of evidence, we're mostly going to refer to the federal rules of evidence. But I want to acknowledge that the federal rules of evidence apply in federal court in the U.S., and they tend to serve as a model for many states, but there are some variations from state to state. Our evidence rules also have to incorporate some constitutional and statutory provisions. So, but we're mostly going to be talking about the federal rules of evidence. As a companion to the federal rules of evidence for the People's Republic of China, for evidence law, we're looking at the criminal procedure law and various judicial interpretations and regulations. Interestingly, both in the federal rules of evidence and the Chinese criminal procedure law, the statements about the purposes of the rules are quite similar. In the federal rules of evidence, it's very explicit in Rule 102 that the purpose of the rules is to ascertain the truth and secure a just determination. And similarly, in the Chinese criminal procedure law, one of the purposes is to have an accurate clarification of the facts in criminal cases. When we think about U.S. trials, it's important to remember some of the key aspects about the trial. And I think one of the ways of describing it is that a trial in the United States is a very dynamic process. All of the evidence only counts as evidence when it's introduced in court and accepted as admissible by the judge. So all of the evidence, almost all the evidence, is presented through witness testimony. As you know, in criminal cases, often the trier of fact is a jury, which is 12 ordinary citizens with no special legal training. And they're hearing the evidence for the very first time at the trial. So it's a very dynamic process. And the presentation of evidence is adversarial. Each side presents the information that they think is most helpful to their case, and they challenge the information or the evidence that is most unhelpful to their case. There's a certain unpredictability to the evidence, because even though an investigation has occurred and the lawyers have prepared, when witnesses testify in court, they sometimes give more details than they've given before. Sometimes they're asked questions that they haven't been asked before. Sometimes their testimony changes. And so the rules of evidence have to deal with the fact that the evidence comes in a dynamic fashion. In contrast, in general, the Chinese system is a little bit more like the continental legal system in that the police investigators put together a dossier of all of the evidence. That would include all the witness statements and other evidence. And all of that goes into a file, gets presented to the prosecutor. Prosecutor might supplement it, and then the prosecutor presents that evidence at trial to the court. So by the time the case comes to trial in China, the evidence is pretty much solidified and is relatively predictable. The witness statements are not going to change. They're written statements. The defense may agree to some of the evidence or may disagree or make some argument about it, but the evidence itself is not going to change. There are very few witnesses who testify in person. And in contrast to the jury system, the judge or a panel of judges will decide what facts have been proven. Those two trial systems, lead to different starting points in thinking about evidence. And in China, as you think about reforming your trial system and having more witnesses testify, you might have to adjust some of your evidence rules to think about evidence a little bit differently. We're going to use a hypothetical case to illustrate some of the points that we want to make in the rest of the presentation. And in this slide, I've just given you some very simple facts about the hypothetical bank robbery case, case where a white man walks into a bank with a gun and demands cash from the bank teller, and the teller gives him $15,000 in cash, which he stuffs in a backpack, and then he runs away from the bank. There's an eyewitness named John Smith who sees the bank robber run away, and he notices he's wearing a white hat. The hat falls off the head of the bank robber as he's running away, and the hat is recovered at the scene. So we're going to continuously ask questions about what evidence would be admissible in court. We're not talking about all of the evidence in the case. We're just picking out a couple of items of evidence. So one would be the eyewitness, John Smith's in-court identification of the defendant. Is that admissible? The second is the eyewitness, John Smith's identification of the bank robber's hat. How do we introduce that into evidence? The third is the hat itself. The hat was recovered at the scene. How do we introduce that into evidence? And I'm just going to add a fact that we're not going to talk about much, but later on in the trial, there will be a witness who will testify that DNA found on the hat matched the DNA of the defendant. And then the fourth item is a post-arrest statement by the defendant. In this case, the defendant did not confess. In fact, he denied that he was involved in the bank robbery, but he admitted that he owned a very similar hat, but he claimed that he lost it before the robbery occurred. So as we talk about the concepts of evidence, relevance, testifying based on personal knowledge, authentication, we're going to come back to this hypothetical and these examples and use them to illustrate the points.
We're going to talk about admissibility, relevance, probative value, prejudice, and the requirement of personal knowledge. They all work together at the same time, synchronously, with respect to the admissibility and the treatment of evidence. Rule 402 in the Federal Rules of Evidence guide the admissibility of relevant evidence. The default position as a general matter is that relevant evidence is admissible unless something makes it inadmissible. We've listed 3 or 4 things here that sometimes make a piece of evidence inadmissible: the Constitution, a federal or state statute, these particular rules of evidence, or some other rule by the Supreme Court. And the last point is irrelevant evidence is not admissible. What do we mean by relevance? Well, if you look at subpart A in this slide, evidence is relevant if it has any tendency to make a fact more or less probable than it would be without the evidence. And that's what I touched on earlier. The default position in American trials is that we'll let evidence in if it's relevant. We'll let the fact finder, the jury, sometimes the judge, but we'll let the jury decide. We'll let the jury hear the witness, see the evidence, handle the evidence, consider the arguments of the attorneys. One way to also think of relevance is in contrast to probative value of the evidence. Relevance is static. It's not dynamic. Either a piece of evidence is relevant, in which case it's presumptively admissible, or it's not. Probative value, on the other hand, sort of the qualitative value of that piece of evidence in determining a particular fact, it can be understood as sort of existing on a continuum. So different witnesses, different articles of evidence may be more or may possess more or less probative value depending on a host of issues. Relevance or irrelevance is the blue line, and it is meant to be static. You know, the hat that the bank robber was allegedly wearing in our hypothetical is relevant or not. That's a static question. How probative that hat is will depend on the facts of the case. You know, if it can be connected to the bank robber, then the probative value would be greater. If there's some question, for whatever reason, about whether the bank robber in fact had this particular hat on, then the probative value may not be as great. I wanted to make one other point about the dynamism present in these trials. The hat in our hypothetical, right, and I think Ira mentioned, which has the alleged bank robber's DNA on it, would seem A, to be obviously relevant, and B, to possess significant probative value. On the other hand, that depends. If the witness, say, who saw the bank robber with the hat on can't be found, doesn't show up to the trial, then suddenly the hat has less probative value because there's nobody to connect it to the bank robber. So the point I wanted to make was relevance and probative value work together, but added to the mix is the dynamic nature of these trials. So as Ira said, a witness may come in and testify slightly differently or surprisingly differently even in a case. And suddenly the probative value of a piece of evidence that you thought was one thing may turn out in just a moment to be something else. Assume an issue of consequences, whether identifying the person who robbed the bank. I mean, who is it? Is it the person on trial? Can we positively identify this person as the person who was in the bank? And there are sort of four posed questions about different pieces of evidence, which has greater probative value. A lineup, for those of you that are unfamiliar, typically takes place at a police station where you might have 6 or 8 potential suspects. They may resemble one another physically, and a witness will come in and without being tipped off about who the real perpetrator is or who the chief suspect is, pick someone out of a lineup. The probative value of an eyewitness picking a defendant in a lineup, an eyewitness who identified a hat the alleged robber was wearing that fell off his head and that was recovered by the police. There's a video, presumably from the bank, that shows the robber wearing the hat that the police later recovered. And then finally, DNA found on the hat that matched the defendant. As a general matter, I think we would say that number 4, the DNA, may well be the most probative piece of evidence because, as I say in my criminal trials, DNA doesn't lie. It doesn't have friends or enemies. It just is what it is. And if it matches the defendant, the bank robber, then it would necessarily connect him to the hat. But consistent with the point I was trying to make earlier, the DNA on the hat is only as probative, only as important as the witness who can come in and say that he or she saw the bank robber with the hat. And to the extent that that witness is credible, right? That hinges on how probative, the DNA evidence is on the hat. To go back to what we talked about in the first couple slides, relevance, the sort of presumptive admissibility of relevant evidence. There are prohibitions against admitting any relevant evidence. And one of the ways that there's a sort of balancing test is in balancing the probative value with the unfair prejudice that the evidence brings into the case. The rule is 403. The court may exclude relevant evidence if its probative value is substantially outweighed by its unfair prejudice, which would be confusing the issues, misleading the jury, undue delay, waste of time, and so forth. The gate for the admissibility of relevant evidence, though it is wide open, is not wide open always and at all times. There are circumstances where a piece of relevant evidence, because it was substantially outweighed by the unfair prejudice, would not be admitted into the trial. Take the hat from our bank robbery hypothetical. What if the hat, we know, right, that the hat has allegedly DNA from the suspect on it, right? So the probative value is not insignificant. And we have a witness who's going to come in and say, I saw the person run out of the bank and he had on this hat, and they'll describe the hat. But what if the hat had a logo on it? What if the hat had something printed on it? Well, whatever the logo was might help the witness identify the hat, make that witness more credible. I'll never forget it. It had such and such a design on it. But what if that design, just by virtue of the design, was somehow arguably prejudicial? So what if the hat had an NYU law school logo on it? What if the hat had a cop killer logo, like that it carried some distasteful message, or at least potentially distasteful to the jury? Would that be enough unfair prejudice to keep the hat, which is relevant, out of evidence? What if it was a New York Yankees logo, but you were a New York Mets fan? What if it was a Bernie for president hat and not a Make America Great Again hat? I mean, these things would go into the consideration that a judge would make if the lawyers made the argument that, yes, I agree, the hat is relevant. However, because it has a original gangster cop killer logo on it, my client is African American. He's going to be associated with this kind of behavior, but he's presumed innocent. The unfair prejudice outweighs the probative value of the hat, and the hat should be excluded.
I just want to point out there is an intermediate position on the hat. It's possible that the hat could be admitted into evidence, but the logo would be concealed from the jury because the logo would be found to be prejudicial. And that creates some problems, but in the balancing test, sometimes a portion of the evidence might be redacted or covered up, hidden from the jury because it's unfairly prejudiced. So I just wanted to make sure we were clear that you wouldn't necessarily lose the probative value of the hat just because it had a prejudicial logo on it. A judge might balance that, find the balancing in a way that is a compromise.
Well, all right, thanks. That's a good point, because it goes back to what we talked about at the beginning of this session, which is the default position is to admit the evidence. So it's not an all or nothing proposition. It's not necessarily, anyway, that the hat comes in or it doesn't. If it's an important probative piece of evidence, the court may decide, well, we'll let in the hat so that the DNA evidence comes in, but we're going to put tape. I mean, that could literally, something like that could literally happen. We'll put tape, masking tape, over the logo on the hat. I'll give you another quick example. Let's say when the police showed up to interview the eyewitness, the person who said he saw the bank robber, he may say something like, he's not going to say, I saw the bank robber come out of the bank. He's going to say something like, I saw the blank, blank, blank person come out of the bank. And whatever he happens to say in his excitement, may not be the most tasteful, polite thing to say about the person who robbed the bank and may have scared him. At trial, even though the way he described the bank robber may be not polite, distasteful, something you wouldn't necessarily want to repeat, the judge may say, well, I'm going to let in the identification, but I'm going to ask the witness not to repeat some of the words he may have used to describe the bank robber, because those would be overly prejudicial to the defendant. There are a host of rules, 404, 05, 06, 410 listed here, that do put some constraints on blanket admissibility of relevant evidence. Rule 404, character evidence, crimes, or other acts. We typically do not, in American criminal trials, admit evidence of prior misconduct that is similar to the charged conduct. So, for example, in our hypothetical about the bank robber, if this guy's a professional bank robber and he's been charged and convicted in a dozen other cases for very similar bank robberies, is that relevant? Yes, it's relevant. This is a guy who seems to make his professional life robbing banks. But even so, he's on trial for this particular bank robbery. And absent other special circumstances, the fact that he's robbed banks in the past is not admissible, because essentially the argument is that it is unfairly prejudicial, Rule 403, which we talked about earlier, to his current trial for bank robbery.
Just want to clarify, when we're talking about the federal rules of evidence, obviously we're talking about a system where there's a jury trial. And what admissibility would mean is evidence that's admissible means the jury is allowed to hear that evidence. And if a judge rules evidence is not admissible, the jury wouldn't hear that evidence at all. When you're having a judge trial, it's a little bit different. Obviously, the judge is going to be aware of the inadmissible evidence, but the judge would make a ruling that she would not base her decision on inadmissible evidence. So I think even though these rules are designed for a jury system, the same principles could apply to a judge trial, and do apply, because we do have cases where the defendant waives their right to a jury trial. And we also have hearings where the rules of evidence apply. So we've covered this fundamental idea of all relevant evidence is admissible, all irrelevant evidence, all evidence that's not relevant is not admissible, unless there's some other rules. But one of the other key concepts of evidence is witnesses should only testify based on what they personally know. And what we mean by that is the witness has to have experienced something. Either they saw something, they heard something, they were part of something, they were present. And so they can give direct testimony about what they experienced. In contrast, if they're only testifying about what someone told them happened, we would call that secondhand knowledge. That's not permitted. We also call that hearsay. And most of the rules of evidence are designed to promote the truth-finding function of a trial. And this is one of those rules. We know from our own experience that if we were present at an event, we would perceive that event a certain way. And if we hear someone else tell us about it, well, then we're only learning about that event through the lens of someone else who might have a bias, who might have focused on certain things, but not other things. So we don't want witnesses to come to court and just tell us what other people have told them. We want witnesses to tell us just what they know. So this is kind of the parallel or companion rule to the hearsay rule, the rule against hearsay. Now, I should say, I think most people know that the hearsay rules in the federal rules of evidence and the American system can seem very complicated. We're not going to go into the details of all the exceptions, but we're going to focus on the core concept. And so the core concept is that hearsay is not admissible, that only evidence that's perceived, experienced by the witness is allowed to be admissible. But we will go into a little bit of detail. So what actually is hearsay? So hearsay would have to be a statement, and mostly it's a verbal statement, but it could include some nonverbal conduct. And to identify who made the statement, we use the term declarant. So that just means the person who made the statement. The declarant is somebody who is not a witness testifying at court. So in other words, Professor Carrington might tell me that the weather in Mississippi today is beautiful. But Professor Carrington is not the witness in court. I am the witness. I will not be allowed to testify about the weather in Mississippi because I have no personal knowledge about the weather in Mississippi. The second part of this is the statement has to be offered to prove the truth of the matter asserted. And this is the part that sometimes gets a little complicated. So let's say for some reason the weather in Mississippi today is an important matter in a case. I could not testify about what the weather is. But if the issue is, has Professor Carrington talked about the weather, I could testify that yes, Professor Carrington talked about the weather, because I do have personal knowledge about whether Professor Carrington talked to me about the weather. I could testify about that. And it doesn't matter if it's a sworn statement or whether it's an investigator's memorandum of the interview. That witness has to testify in court. That's the only way they can provide the information that's contained in the witness statement. So we're not allowed to use written statements taken before the trial as a substitute for the live testimony of the witness. And the only real exception to that would be if the parties agree. Let's say the prosecutor and the defendant agree that if the witness were called to testify, this is what they would say. There's no dispute about that. But unless absent that agreement, which usually doesn't happen, that witness must come to court. I want to talk about another very specific example that commonly occurs in criminal cases. Here I've used the phrase, the defendant's post-arrest statement. And I use that intentionally because sometimes the defendant, after they're arrested, makes a confession. They admit that they committed the crime, or they admit that they were present and may have participated in some of the criminal activity. But sometimes the defendant, after they're arrested, denies being involved in the crime. So their statement is not a confession. We would just call it a post-arrest statement. Now that's similar to a witness statement. It's written down. Sometimes it's signed by the defendant. Sometimes it's a memorandum prepared by an investigator. So it looks like a witness statement. But according to our rules, a post-arrest statement by a defendant, when it's offered by the prosecutor, is not hearsay. So this is where sometimes people get confused. It is an out-of-court statement, and it's offered for the truth of it. But when it's made by the party opponent, the defendant is in court. The defendant has the opportunity to cross-examine the witness or to testify and dispute what was in the statement. So under our rules, a defendant's post-arrest statement, if it's offered by the prosecutor, is always admissible. So I make this point because many cases, not all cases, have confessions or post-arrest statements. And it's not difficult for them to be admitted into evidence, even if the defendant does not testify. Now, sometimes a defendant in their post-arrest statement doesn't confess, and they give some explanation or some alibi or some defense. Now, if the defendant offers that in evidence, it's not admissible. And why is it not admissible? It's because the prosecutor doesn't have a chance to cross-examine the defendant. And so if the defendant wants to put in a defense of an alibi or some other explanation which is contained in their post-arrest statement, they might have to testify or call other witnesses to put that evidence into the trial. The other category of statements that commonly are found in criminal trials are statements that are not offered for the truth of them, but for the fact that the statement was made. So one example in the bank robbery case is if the bank teller testifies or is asked, what did the defendant say to you when he was in the bank? That's an out-of-court statement. The teller can testify, well, he said, give me all your money or I will shoot you. So the fact that the defendant said that is relevant, even if he had no intention to shoot the teller. So that's a statement that's not offered for its truth. It's offered for the fact that it was said. And the fact that it was said is, of course, very relevant in a bank robbery case.
The authentication piece, it can be cumbersome. It can be overly formalized. But depending on the piece of evidence, for example, but the presumptive concept is that relevant evidence, whether it's testimony or a piece of physical evidence, should come in. So in other words, yes, there are some requirements for authentication, but at the end of the day, the idea is to admit relevant evidence. It doesn't matter if it's a photograph. It doesn't matter if it's a gun. It doesn't matter if it's a hat. It doesn't matter if it's a bloody shirt. If it's relevant and otherwise admissible, it should come in, even if there are some steps with respect to its authentication. Essentially, what authentication is it's just trying to document that the evidence is what it purports to be. The evidence is what it purports to be. Let's take the bank robbery hypothetical. Presumably, if you were the prosecutor in that case, you would like to show the jury what the bank looked like, just so that the jury could have a context for the evidence that they're considering. Where did this happen? What did the bank look like? Now, the jury can't go to the bank. They're in the courtroom. But the prosecution in our hypothetical would likely have a photograph, an 8x10 photograph, maybe blown up, of the bank. The question, based on Rule 901 is, well, is that really the bank? Is that really the way the bank appeared? So in order to get that photograph in, it needs to be authenticated as being a fair and accurate representation, in this case, photograph of the bank. Simple, right? We don't want to put in a photograph of a different bank. We don't want to put a photograph in of the way that bank appeared 30 years ago. We want the photograph of that bank as it appeared on the day of the bank robbery. And so the authentication piece, as you can see from that example, should be relatively simple, and it is. You would put the witness up who took the photograph, a police officer, say, and you would say, Officer Smith, I'm showing you this photograph. Is this a fair and accurate photograph of the bank as it appeared on the day it was robbed? Your witness says yes, photograph comes in. So I just wanted to take that very simple example to say, the authentication piece is not typically difficult, and it just satisfies that one requirement, which is that the evidence is what it purports to be. These three pieces of evidence are very different, and they require different processes of authentication, but all for the same purpose. A witness statement, real evidence, and a confession. A witness statement may likely be hearsay, and so it may not come in the first instance, but there are circumstances where it might. We won't get into them now, but the question would be, is this witness statement what it purports to be? Is it, in fact, the statement of the witness? And so for authentication purposes, you would need, whether you were the prosecutor or the defense attorney in a criminal trial, you would need a witness who was testifying, who could say with firsthand knowledge that this is, in fact, the statement of this witness that was given on a certain day at a certain time. It may be the witness herself, or it may be the police officer who took the witness statement. But in either scenario, either one of those witnesses could testify that this is, in fact, the authentic document or the authentic statement. Take, in our hypothetical number 2, the real evidence, a thing. And by real evidence, we typically mean, but not always, but we typically mean physical evidence. In our hypothetical, the physical evidence is the hat. The prosecution, if it's using the hat, would have to call a witness who could testify that this is, in fact, the hat that the defendant was wearing. Or put differently, this is, in fact, the hat that was picked up on the street that the defendant dropped as he was running away from the bank. It would have to be authenticated as being the item of evidence that it purports to be. And so in example number 2, you might need 2 witnesses. You might need, for example, the eyewitness who saw the hat fall off of the suspect, of the defendant, and you would show the witness the hat, and he would say, yes, that's the hat. That appears to be the hat that I saw fall off the defendant. And then you might also have to call the police officer who actually physically recovered the hat to say, that's the hat that I picked up on the corner of 3rd and Main Street, and I put in this plastic bag, put my initials on it, typically is the way you're asked in court, and that's the hat. And it would then at that point presumptively be the thing that it purports to be, the hat that the suspect wore. Number 3, the confession. As Ira said in the last section, one of the hearsay exceptions is a defendant's prior statement. The confession would be the defendant's prior statement. So under this scenario, it would be an exception to the hearsay rule, and it could come into the trial. But before it could come in, it would need to be authenticated. Likely in that scenario, you might call the detective who interviewed the defendant. And at a certain point, after you had introduced the detective to the jury, you would ask the detective, did you meet with the defendant? Yes, I did. Did the defendant make a statement? Yes, he did. I'm now going to show you the statement / confession that the defendant made. Can you identify this? Yes, I can. What is it? It's the conversation we had written down on April 3rd, 2019, 2 hours after the bank robbery. At that point, you have authenticated the confession. It is what it purports to be. So, sort of the point I'm trying to make, I hope I'm making, is that there is an authentication requirement for evidence, but it is typically not very complicated. You just have to show that the piece of evidence is what it purports to be. But if we look at these 3 pieces of evidence, the witness statement, the real evidence, the post-arrest statement by the defendant, as we wrap up this 4th and last session, is the witness statement relevant? It is. How do we authenticate it? Well, either through the witness herself, for example, that gave the statement, or from a police officer, say in a criminal case, that may have taken the statement. And is it admissible? It's relevant, we've decided, and we know that relevant evidence is presumptively admissible, but whether or not it's admissible will depend on, to harken back to Ira's session on hearsay. Is there an exception to the hearsay rule that would allow it? The hat, number 2, real evidence, a thing. Is the hat relevant? Surely it's relevant. Under our hypothetical, the eyewitness says he saw the robber with it on, and we now know that it has the defendant's DNA on it. It's relevant. How do you authenticate it? We talked about that. You would probably call the eyewitness who saw the robber with the hat on, and you would call the police officer that recovered the hat so that it is what it purports to be. And barring anything else, it's relevant. It would be admissible. And the post-arrest statement by the defendant, as Ira said, is a hearsay exception, because even though it was an out-of-court statement, there's an exception for statements made by defendants. Is it relevant? Yes, especially if it's a confession. Is it authenticated? Not yet, but we know that's easy because we'll call the police detective who will testify that she's the one that interviewed the defendant on whatever date, and this is in fact a memorialization of what the defendant said, and it's admissible. Yes, there is an authentication requirement in the federal rules of evidence, but almost without exception, it's not terribly difficult to authenticate a piece of evidence. What is sometimes difficult is the formal aspects of doing it. You may have to line up 2 or 3 witnesses. You may have to call them in a certain order. You have to know how to navigate through the courtroom, who to go to first, and then second, and then third. But beyond that, as a theoretical matter, authentication is not that difficult.
That was great. Thank you. I just wanted to add a couple of points. On authentication, if the object is unique or somewhat unique, like the hat, it's relatively easy to put it in evidence. There are certain kinds of evidence, like drugs or money, that are not unique. So how do you put those in evidence? And we've gotten a lot of questions from our Chinese colleagues about chain of custody. And chain of custody is also not terribly difficult to prove. When the police seize drugs or money or guns, they have a procedure where it's marked at the time that it's seized, and it's placed in a secure location. And anyone who who has access to that item has to sign a log, so that there's a complete record of where that evidence has been from the time it was seized until the time it's brought to court. So most of our authentication is done through a witness who has personal knowledge of the evidence. And that having witnesses in that case makes authentication easy. This is an actual indictment of a bank robbery case from my old district in the Eastern District of New York, and added the witness statement from John Smith, and also the post-arrest statement. I want to just make a comment about the post-arrest statement, and then I'd like to show you a video. On the post-arrest statement, if the prosecutor offers it, it's not hearsay. But in this post-arrest statement, what the defendant said was he wasn't near the robbery, wasn't near the bank at the time of the robbery. He wasn't involved in the bank robbery. And as far as the hat was concerned, he said, sure, I used to have a hat like that, but I lost it a long time ago. So that's kind of what we would call an exculpatory statement. He's saying, oh, you may have my DNA on the hat, but it had to have been someone else wearing the hat at that time because I lost that hat months before the bank robbery. Now, the prosecutor might not want to put that statement in evidence because it's not particularly helpful to the prosecutor, unless maybe the prosecutor has a photo of the defendant wearing that hat the day of the robbery, which could then prove that the defendant's post-arrest statement was not true and would be further evidence of guilt. We're just going to show you a demonstration from a law school class.
But in this particular case, the premise will be a Crown attorney leading real evidence through an eyewitness to a bank robbery.
Mr. Smith, where were you at 4 o'clock?
I was at the bank.
What were you doing at the bank?
I had to do some transactions. I had to cash some checks.
Did anything out of the ordinary happen while you were at the bank?
Yeah, as I was leaving, the alarm went off and I saw a man running from the bank.
What direction was the man running?
He was running away from the bank and down the road.
Was this man carrying anything?
Yeah, he had a gun in one hand and a backpack in the other.
Was this man wearing any distinguishable clothing?
Yeah, he had a white hat on with blue and gold accents. I think it was an Edmonton Oilers hat, and it fell off his head as he was running.
Mr. Smith, I'd like to show you an item.
The first step is introducing the exhibit. Here, the prosecutor has started this process by saying, I'm going to show you an item.
Mr. Smith, do you recognize that item?
Yeah, that's the hat the man was wearing when I saw him leaving a bank.
The second step is showing the exhibit. Here, the prosecutor first showed her friend, the defense counsel, what she was going to show to the witness, and then presented it to the witness.
Can you describe the hat?
Yeah, it's a white hat. It's got navy blue and gold accents, and it's got an Edmonton Oilers logo on the front.
The third step is proving the exhibit. First of all, the exhibit has to be relevant to a matter in the case, and it has to be authentic. So it has to be what it actually purports to be, and the witness must be qualified to tell the jury or the judge that it is what it is.
Your Honor, I'd like to tender this as Exhibit 1.
Is there any objection to that?
No, thank you, Your Honor.
Thank you. It can be marked as Exhibit 1.
The fourth step is marking the exhibit. Once the foundation for the exhibit has been laid by the witness, the counsel will generally approach the bench and ask that the exhibit be marked in the case. Usually it will be given a numeric exhibit number, and that will be designated by the clerk of the court or the judge.
Mr. Smith, you've indicated that you've seen the hat on a man's head. Is that man in court today?
Yes, he's sitting right there.
For the record, the witness is indicating the accused.
Thank you. That indication is noted.
The fifth step is using the exhibit. So in this case, the exhibit has been used by this witness in identifying the accused. But later on in the case, the exhibit may be referred to by other witnesses. For example, a DNA expert who matched DNA in the hat to the accused person.
An example of real evidence being tendered through a witness. It gives you the broad basics and the reasons behind each particular step that you saw. So good luck.
So that's our presentation. Our goal today was to try to introduce these fundamental concepts of evidence. Basically, as Tucker mentioned, the default position is all relevant evidence is admissible. That gives us, a judge, the most flexibility in deciding what evidence should be, the jury should hear, or what evidence should be the basis of a decision. But then certain kinds of evidence, even if they might be relevant, are excluded either because they're not reliable, like a hearsay statement, or because of some other consideration of unfair prejudice. There are some other rules like attorney-client privilege where relevant evidence is also not admissible, but wanted to focus on the general concept that any evidence that's relevant would be admissible. The other second fundamental point is that when witnesses testify, they have to testify based on their personal knowledge. They can't testify based on what other people told them. And also, we can't use out-of-court written statements like witness statements to substitute for the live testimony of witnesses. And that's the fundamental principle of the rule against hearsay. And then the third point is that every piece of evidence has to be authenticated. And while that is a fundamental requirement, it's not difficult to meet.
Yes. And in fact, to go back to what I said, it's a great question. And to go back to what I said at the very beginning, these trials are very dynamic with the way that we treat the admissibility of evidence. But that said, and consistent with at least my personality, which is to control what happens in court, you can, as a lawyer, file a motion or bring it up orally before the trial starts that you think that a particular piece of evidence, or you suspect that a portion of a witness's testimony may be problematic, may be overly prejudicial, and you would like the court to rule on it in advance. And that way you know with some greater certainty that that particular piece of evidence or that particular portion of testimony is not going to come in. Can I give a quick example? Oftentimes, I'm a criminal defense lawyer. Oftentimes, the prosecution will want to admit a series of photographs, often of the crime scene. I'm thinking of a homicide case. A number of those crime scene photos can be gruesome. They can be unpleasant to look at. The question then becomes, how many of those photos does the prosecution really need to demonstrate that there was a homicide? They probably don't need all 40 of them, probably need 10. And of those 10, 3 of them, I think, are so bad, so gruesome, so horrifying that I would argue that those 3 would be violative of Rule 403 and should be kept out. And the judge would make a ruling on that, and then I would know. I might win, I might lose, but I would know what the evidence was going to be before the photographs were admitted into the trial.
It's great. And I would say another common example is if a witness or the defendant has a criminal record, the lawyers would want to know in advance, are they allowed to question the witness about the criminal record? It might affect whether they decide to call the witness or not. So, the character evidence that Tucker talked about being admissible or not admissible, you want to get as many of those questions resolved before the trial as possible. In the pretrial conference, you can certainly do what Tucker just suggested, ask the parties, what's in dispute and what's not in dispute. To make that process meaningful, the prosecutor has to make the evidence available to the defense attorney in advance and to give them a sufficient opportunity to understand that evidence so they know whether or not to agree to it. So in that case, you could save time. If there's no dispute that this hat was found at the scene of the robbery, there can be a stipulation, which is just a fancy word for an agreement, that this is the hat that was found at the scene. It may or may not be, it depends on the defense in this case. If the defense is the defendant was not present at the robbery, he might want to, challenge the hat. But if the defense is, yes, I was at the bank, but I'm not the bank robber, they somehow could make that defense, then the hat's not that important anymore. So you could agree to it. In many narcotics cases, there's no dispute. The defense is usually not, it wasn't narcotics. It's usually, I didn't know there was narcotics. But I will say in our system, the defendant has an absolute right to insist that the prosecutor prove everything. And the defendant can just say, I plead not guilty, and I want the prosecutor to bring all the evidence here and prove it. And I will say this, let's say the police lose some of the evidence. Let's say they're sloppy and they don't do a good job of keeping the evidence secure. Well, in a drug case, without the drugs, the defendant will be acquitted or the case might be dismissed. The physical evidence is important, but you can shorten the trial and you can use various ways. If you have witnesses testify, which are the witnesses that really need to testify? And that's, I think, a hard question for us to answer in the abstract. In a specific case, it would be the questions that are in dispute where the witnesses have to testify. That's something that the defense lawyer, in consultation with their client, after seeing the evidence of the prosecution, can make a judgment about. But it's very hard to make a blanket rule and say this category of evidence witnesses must testify and this other category of witnesses doesn't have to testify. There are some rules because in trials there are recurring situations that come up over and over again. And so the rules anticipate certain common fact patterns. So, for example, it's common in criminal trials that some witnesses will have a criminal record. So we have specific rules about when is that relevant? If the criminal conviction was 20 years ago, well, that may not be relevant to whether this witness is credible. If the conviction was for a very minor crime, like maybe shoplifting, it might not be relevant. But if it was a recent conviction last year for perjury, for giving a false testimony, well, that would be very relevant to whether you could believe the witness. So in the federal rules of evidence, there's an attempt to help the judge by clarifying in certain situations what is relevant and when does the unfair prejudice outweigh the probative value. This balance depends on what the other evidence is. In the bank robbery case, the defendant committed many bank robberies before and was even convicted, but the fact that he committed other bank robberies doesn't mean that he committed this bank robbery, and he's still entitled to a presumption of innocence. On the other hand, if he committed the bank robberies using a very unique methodology, maybe he always wore a particular kind of mask that's very hard to find, and that he always said the exact same words or used kind of a note that was very unique. Well, you might be able to use that prior evidence of prior bad acts, to show that the defendant acted consistently. And it's a way of identifying this person that no other bank robber would likely use that kind of methodology. That would be dangerous because the jury might decide, well, he's committed other bank robberies, so let's just convict him of this one too. So you'd have to be very careful. If you change some of the facts, then you change the analysis of probative value versus unfair prejudice. And you change the balancing test about admissibility. So I think you can have some rules that are helpful for judges, but you have to be careful. You don't want to tie the judge's hands and force them to make a choice that may not be the right one under all the circumstances. So these rules of evidence do give judges a lot of discretion and rely a lot on the ability of the judge to make appropriate judgments.
Ira makes a good point. There are rules which about the admissibility relative to unfair prejudice, and those rules do provide a structure, but there are circumstances where rule doesn't really apply, and where, to your question, a kind of judge's common sense would determine its admissibility. In the example, I have a quick example. I one time had a murder case. My client was male. The victim was female. When the police showed up, one of the police officers, who was a female, was taking photographs of my client. My client had blood on his clothes. And during the course of taking some photographs, my client made a wildly offensive, sexually charged comment to the female police officer. It was horrible. It was any right-thinking person would have been deeply offended. I, consistent with the earlier question, moved before trial started to keep that comment out. It wasn't, my argument was, whatever relevance it may have had to whether my client committed the homicide or not, which, by the way, I argued was very low. All this happened long after the alleged homicide. The fact that my client would have said that thing, which was so offensive, was just going to prejudice the jury against my client. That was not the question that they should have been deciding. Put differently, I would agree that my client acted like a jerk, may have been a jerk, but just because you're a jerk doesn't mean that you committed the murder. And so this judge, by the way, who was no friend to me or my client, agreed with me. and used her common sense. There was no particular rule that kept that out.
So I don't have any empirical research, and my guess is that a lot of prosecutors feel that judges exclude that evidence too much, and a lot of defense attorneys feel they don't exclude it enough.
As we've said, the default position is that evidence comes in. Sure, evidence is often prejudicial. I mean, that's why it's relevant, and it's otherwise admissible. So my experience has been that judges do not very frequently preclude evidence under just a general 403 weighing test. And unfortunately, I find more often than not that lawyers really don't have a really solid working knowledge of the rules. And that raises this issue, is the point I want to make. A little knowledge is a dangerous thing. And one of the things I see happening with the rule-based system like we have is those folks in positions of power, whether they're judges or lawyers, can use, sometimes consciously, sometimes not, these rules the wrong way. And it leads to problems, either an unjust result or a process that's just is not right because the rules of evidence are not being used correctly. So I guess my sort of point is, as you all are thinking about this, that you also think, I will say that our rules to me make sense, especially once you look at them all in a continuum. They make sense and you understand them. But I do think that we all ought to also be aware that to the extent that they're complicated, to the extent that they're not well taught, they can, on occasion, become impediments to, rather than something that is supposed to be helpful to, a just conclusion.
I'm not going to disagree with Tucker, but one of his areas of practice is wrongful convictions, and seeing a lot of cases where innocent people have been mistakenly convicted. And so he's got a ton of experience seeing how even when the rules are applied, they led to mistaken outcomes. I think the basic concepts are valid. I think the requiring people to testify based on personal knowledge is really important. I think authenticating evidence is critical. Our, I would say, flexible approach to admissibility really depends on people exercising good judgment. Sometimes a judge can let evidence in for a specific purpose, but then give the jury an instruction and say, I'm only allowing this evidence in for you to determine X, Y, Z. In the example of the bank robber and the prior conviction case, I'm only letting this evidence in to the extent that you think this method of bank robbery is so unique that it helps you decide the question of whether or not this defendant, it identifies this defendant as the perpetrator. But you are not to determine that he's guilty simply because he may have committed other bank robberies. That would be a difficult instruction for anybody to follow. So I'm not sure that's a great example, but I just want to point out there are sometimes compromised positions that judges can take on these questions.